Hello and welcome back to the channel. My name is attorney Stanley Helensky. I am an attorney of about 25 years. I practice in trial courts and appellate courts, First Circuit Court of Appeals, federal courts, even family courts. Today we're talking about a First Amendment case as it relates to the Karen Read murder case that's been sort of ruminating around the news media for some time now. Briefly, this is not a discussion of the actual murder trial. Maybe I'll do a video about that later. This is a case about a really fascinating issue that happens in cases like this all the time. Not all murder trials have the popularity that this case has. I've had a murder trial where there was literally nobody in the courtroom but me, the defendant, the three prosecutors, the judge, and the jury. There were no protesters, no media reports. It was literally just a month-long trial with all the twists and turns that murder trials have. This would be a quick one, but it came across my radar and I thought it'd be an interesting issue that I would bring to you. The case is Tracy Ann Spicuzzi and others versus the Commonwealth of Massachusetts and another. Docket number SJC 13589. It relates to the Karen Read murder case. This case has been in the press pretty much nonstop, so let's talk about it. The issue is that every day that the court is taking testimony, there's a whole bunch of people seemingly in support of Karen Read outside of the courthouse and who are protesting. Anytime that you hear protest in the law, the focus is immediately on First Amendment of the Constitution. That's what should come to mind. So this case is no different. Briefly, the First Amendment of the Constitution involves free speech. At least in some part, there are other freedoms that are announced in that amendment. But the crux of the First Amendment is the right to free speech. In these kinds of cases, the courts have tons of difficulty because the protesters have a right to protest without being cut off from the government, but the court has to make sure that the trial is fair. What was happening was that witnesses against Karen Read that were called by the prosecutors in an attempt to prove her guilt were coming into court each day past the protesters who were yelling at the witnesses and probably in some ways intimidating them. I have no idea if that took something off the anticipated testimony, but I'm sure that the witnesses were somehow affected by the protesters. It'd be difficult not to be affected as you walk by. But even more significant was that the actual jurors in the trial had to walk past these protesters every day before trial. Now, that's a huge problem because in every trial, you need to have jurors who are independent, unbiased, and unaffected by anything other than the evidence that's actually introduced in that particular case. So that's the real problem. But it's impossible to avoid hearing what these people are saying, no matter what that is. It's giving information to the jurors, even the potential jurors, in a form that's outside of the trial and likely inadmissible, evidence or information that is not part of the particular trial that may potentially influence those jurors and the decisions that they ultimately will make or the verdict that they ultimately give. Let me explain this. When we pick juries for trials, first of all, it takes forever. We have to first take the whole pool of potential jurors, which is whoever showed up for jury duty that day. Then we ask them a bunch of general questions about the jurors' beliefs to see if they have some pre-existing biases that may make them unfair as a juror for the trial. So, for example, they're asked if they would believe the testimony of a police officer over the testimony of a civilian witness. And the reason we ask that is that every single witness should be on level footing, at least as the trial begins. So if the potential jurors' answer to that question is yes, in the affirmative, they probably shouldn't serve as a juror. Because again, every witness, regardless of rank or employment, should be on the same level footing as other witnesses before the trial starts. So after the general questions, we go through individual case-specific questions to see if there's any potential bias against the defendant. They may know the defendant. They may know witnesses in the trial. They may have some bias against the race of the defendant, the gender of the defendant, and others. It's really the same issue. We go through great pains to weed out people who may bring into the courtroom these pre-existing biases or prejudices that may cause a potential juror to decide the case differently from other jurors that don't have these pre-existing biases or beliefs. So I am also allowed to strike jurors. It's called preemptory challenges for reasons that are in my head, that I don't like the way that they're looking at my client, or I don't think that they're going to be fair, or I don't think they'll be fair for reasons that maybe the court doesn't agree with, but I believe to be true. Then on top of that, after we pick the jury, and the jury is sat and sworn, the court instructs the sitting jurors not to do any research outside of the courtroom, like Googling or asking people about certain witnesses or otherwise. The evidence must be limited to the evidence that's introduced in the courtroom in an admissible form, period. So there's a huge amount of work that has to go into picking these juries. Now, all that being said, here we have these jurors that have been vetted and vetted and vetted, walking by protesters every day that are screaming out whatever about the case that they're deciding. So in this case, you have these people standing outside the courthouse, seemingly on the side of the defendant, and who knows if a sitting juror is going to hear something from one of these protesters that's going to change his or her mind. Either way, the sitting jurors are now hearing something about this case outside of the courtroom, as they're instructed specifically not to do. There's the problem. So the right of these protesters to protest under the First Amendment conflicts directly with the court's need and the defendant's need to have a fair trial, not influenced by information conveyed by the protesters. So then what do? Do you allow them to protest or tell them that they can't protest? Like, whose rights are more important in this scenario? So let me tell you a little bit about what lawyers and judges do in these situations. The reason you have lawyers and judges in courts is to try to find a gray area where there are rights in direct conflict with one another. That's what happened in this case. The trial court, by the prosecutor's request in this case, ruled that instead of prohibiting the free speech or allowing it to happen and to influence witnesses and jurors, the trial court ordered the protesters to keep a 200-foot border around the entrance of the courthouse. So there was a 200-foot buffer around the courthouse where protesting was prohibited. That's what the trial court ruled. Well, the protesters didn't like this, and they saw this as a restriction on their right to protest, so they filed a petition with the Supreme Judicial Court, the highest court in the land. And the court upheld this 200-foot border around the courthouse, protecting witnesses and jurors, indicating that the right to petition or protest is not unlimited, and that truly is the law. The SJC recognized that courts may affect a person or party's rights to petition, and have said in the past that the government may impose reasonable restrictions on the time, place, or manner of the protected speech, provided that the restrictions are justified without reference to the content of the regulated speech, but are narrowly tailored to serve a significant government interest, and that they leave open ample alternative channels for the communication of the information. That's DeRochier versus Governor, 486 Mass 369. It's a 2020 case. Here, the protesters, which I believe included the American Civil Liberties Union, claimed that the state was in fact focused on a particular side of the speech because it was practically only limiting the speech of the protesters in support of Karen Reed. So they were saying that the trial court essentially was looking at the content of the speech because they were only limiting, the trial court was only limiting the speech of the protesters against the prosecution in favor of Karen Reed, and therefore limiting only the speech of the protesters in support of Karen Reed. Well, the SJC disagreed with that. The buffer around the building applied to all protesters. Just because only Karen Reed supporters were the ones who were out there protesting, and it would only be Karen Reed supporters who would have their speech limited to this 200-foot barrier border, didn't mean that only one side was being regulated. Anyone who was going to protest outside of that courthouse would have to follow the 200-foot rule. The SJC held that because the buffer applied to any protesters, even if practically it was limiting only those of the defendant's supporters, that the court's buffer was a reasonable restriction given the competing harms, that it was reasonably tailored to meet that harm, and that the protesters were still allowed to protest, just not in a way that would influence or potentially influence witnesses or jurors. This was a wise decision, in my view, of the trial court. It was a wise decision of the SJC, fairly encompasses the law. Free speech is not limitless. Restrictions may be placed on speech, as we've seen in the Donald Trump criminal trial, where there's a significant government interest and the government takes all necessary precautions to tailor the restrictions to a situation at hand to the greatest extent possible. It's lawful. So thank you for watching. I think I may post some content on the Karen Reed murder trial, potentially on the Donald Trump and Stormy Daniels payoff trial and allegations. If there's a topic that you'd like for me to discuss and analyze, please leave it in the comments. I'm happy to post something along those lines. If you've enjoyed this content, please consider subscribing to the channel. This is a brand new channel that'll share legal insight into issues that are before us all. As always, this video is general information related to a specific case. The information contained in this video may or may not apply to your specific case. If you do have a set of facts that you want to apply to the law, you should always speak with a lawyer before coming to any conclusions about your case. So once again, thank you for watching, and we'll see you in the next one.